Hello and welcome to Taylor Wessing's webinar on sexual harassment in Europe. My name is Paul Callaghan and I head up our employment, pensions and mobility team in the UK. Today I'm joined by Joe Aiston and Roxane Bradley from our UK employment law team and by Brigitte Sammer from our Vienna employment law team to discuss the different ways in which sexual harassment allegations are dealt with across Europe. We scheduled this webinar several months ago in the light of an increased number of high-profile sexual harassment claims that were being brought, in particular amongst tech companies in the US. The Ellen Powell case springs to mind immediately, as well as allegations made by people working for Uber. And since we scheduled the case, sexual harassment in the workplace has become a far more topical issue in the UK and to some degree in continental Europe as well. And more allegations are coming to light. The way that those allegations are dealt with has both potentially legal liability issues as well as important PR issues for companies, which also needs to be dealt with. A large part of dealing with sexual harassment in the workplace is ensuring that everybody is properly trained in the workplace, and your participation in this webinar will go some way towards demonstrating that there is a commitment to dealing with inappropriate sexual harassment in the workplace in your company. Culturally, there are major differences across Europe in relation to sexual harassment law. Nowhere is there compulsory training required the way you have in California and some other states in the US. And in much of Western Europe, sexual harassment claims are extremely rare and almost unheard of. That's partly because of the extensive employment law rights that employees in those countries have anyway, so people don't feel they need to get into the specifics of sexual harassment when they make a complaint. But it's also cultural, and behaviour in the workplace. What is considered acceptable behaviour in the workplace does vary from country to country. Needless to say, that poses challenges in this day and age of globalized businesses and with frequent secondments of employees from diverse cultural backgrounds to other countries. And so it's absolutely necessary to ensure that there's good, appropriate sexual harassment training in every workplace in which an employee in a business is going to be stationed, even if it's for a relatively short period of time. The UK generally is not as litigious in this area as the US. However, that is starting to change. In dealing with these issues, carrying out a proper investigation and understanding the law and its potential limits is absolutely key. So I'm going to hand over now to Roxane Bradley, who's going to talk us through what exactly we mean when we talk about sexual harassment.
So this slide focuses on the law on sexual harassment in the UK. And as you can see from the definition on that slide, it occurs when A engages in unwanted conduct of a sexual nature, and that conduct has the purpose or effect of either violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. Now, in deciding whether that conduct has the effect, each of the following needs to be taken into account. Now, those things are B's perception, the other circumstances in the case, and whether it's reasonable for that conduct to have that effect. So the conduct will only be considered to have the necessary effect on B, where it's reasonable for it to have had it. So therefore, provided any offence caused is unintentional, there won't be a claim for harassment if the victim is hypersensitive, and it was therefore unreasonable for it to have that effect. Now, the question of reasonableness in this context is a matter of fact for the tribunal to determine. And in determining it, the tribunal needs to have regard for all of the relevant circumstances, including the context of the conduct. It's also important to note that it can be a single act, and it doesn't need to be an ongoing campaign of harassment in order for the law.
So Roxane, that's very different then, isn't it, from the US, where a single act is not normally enough to constitute.
Yeah.
The key takeaway from anyone who's used to dealing with US issues is that one act may be enough for liability.
So Brigitte's now going to briefly discuss the law in Central and Eastern Europe in this area.
Thank you, Roxane. In Central and Eastern Europe, the rules and conditions are mainly the same as described by Roxane. due to the fact that EU law has already been implemented in most of the CEE countries. But here I would also like to point out that in several CEE countries, implementation took place. However, the means for affected people to exercise their rights are rather ineffective or simply not yet utilized. Nevertheless, it can be observed, especially in Austria, that sexual harassment at the workplace becomes more and more a topic before official equal treatment institutions as well as in court proceedings. In this respect, the highest court in Austria has already worked out some principles when ruling on sexual harassment accusation. One principle concerns the obligation of a party concerned and the question whether or not this party has to react and to explicitly reject the harassing conduct. But it has in general not. It must only be clear for the harassing party from the circumstances that a conduct is unwanted. And this must often be assumed, particularly in case of physical contact. In most CE countries, equal treatment rights can be found not only in general civil codes, but also in labor law, so that it is especially applicable in employment relationships. However, in some countries, such as the Ukraine, the implementation in the labor code, like the whole labor code, is still under discussion. Furthermore, in the Ukraine, it applies in general in vertical relationships, and that's, for example, not between employees. This is, however, not the case in Austria and many other CE jurisdictions, where the employer has to provide for a non-humiliating environment, also among employees as well as employees and customers or other employment-related third parties. This was a rough overview on the law in CE.
Okay, thank you, Brigitte. Roxane, I think you're going to take us through some examples.
Yeah, so these examples stem largely from UK case law. So the first one focuses on whether or not conduct is conduct of a sexual nature. Now, this case was actually determined pre the Equality Act 2010, which is where our sexual harassment laws come from. But it's largely considered that these are the kind of facts that would most likely give rise to conduct being of a sexual nature. And the Equality and Human Rights Commission Code also suggests that this is likely to be considered conduct of a sexual nature. And this case focused on a data entry clerk who worked evening shift. And she gave evidence that during her shift she was aware on 3 separate occasions that male colleagues were downloading pornographic images onto their computer screen. Now, she wasn't shown the images, and she didn't make any complaint at the time. She only complained afterwards that the conduct was still held to be conduct of a sexual nature. It's also important to note that the employee having put up with the conduct for a long period of time, or even initiating it by way of a coping strategy, doesn't mean that it can't be unwanted. So a specific case here was in relation to 4 waitresses working in a restaurant. It was run by a man called Mr. Moss. The claimants were all migrant workers from Europe, and they had between 1 and 5 years service. They alleged that throughout their employment they were made to wear short skirts and subjected to talk of a sexual nature by Mr. Moss. He showed them explicitly sexual photographs that were lying around in the restaurant, and he regularly asked them questions about their sex lives. Sometimes they would then ask him questions about his love life, as they found that this made him easier to handle. On occasions, they'd attempted to complain to him, but he became angry when they did so, and when they complained about his behaviour to the male manager, he was basically saying that there was nothing he could do. The assistant manager, who was a female, acted as a buffer between the waitresses and Mr. Moss, and they said that that helped them keep some kind of equilibrium, which made them be able to continue with their employment. When the assistant manager left her employment due to illness, all 4 claimants said that they found their positions untenable and they resigned within 3 months. And for one of the claimants, things came to a head when Mr. Moss shouted at her. The claimants brought claims for sexual harassment, and the tribunal upheld their claims. and Mr. Moss and the company were held jointly liable for the discrimination harassment awards. Now, the company appealed on several grounds, and one of the grounds on which it appealed was that the decision was perverse and that no reasonable tribunal could have concluded that they would have put up with such intolerable behaviour for such a length of time. And they also said it was perverse to find that the conduct was unwanted when some of the conversations had actually been initiated by the women. But on appeal, the Employment Appeal Tribunal dismissed this. They said it absolutely wasn't perverse, and the tribunal had been entitled to accept that this was a tactic used to divert attention away from their own sex lives. They compared the situation of these women to battered wives who put up with violence even though it's unwelcome, and said that it's not beyond the scope of reason to think that women in that situation might behave in the same way as they did. Thirdly, an employee can succeed when a consensual relationship ends and the other party's conduct then becomes unwanted. And specifically, the tribunal has upheld a decision that an employee had been sexually harassed for 2 days after an 18-month relationship with her work colleague ended. This brings us on to the topic of love contracts and how useful they might be in the UK. So very briefly, it's a document that two employees in a relationship sign to confirm that they haven't been coerced into the relationship with a view to preventing them from being able to allege sexual harassment later down the line. They're not particularly common in the UK, and here it would be more common for a policy on romantic relationships in the workplace to be found in the staff handbook. Now, those policies usually prohibit managers from dating employees in their reporting lines and so on, and include safeguards to prevent confidential information. Now, I think what's important to note is that a love contract, whilst it could potentially provide or help you with suggesting you've taken reasonable steps to prevent harassment, it could also be considered to be a step too far in the UK in light of privacy laws and so on. What we'd recommend would be probably a better way of trying to provide a defence of such claims would be to have a full equal opportunities policy and anti-harassment and bullying policy in place, ensure staff are aware of its existence, and also to run anti-sexual harassment training on an annual basis, ensure that all your employees attend and also sign training records to confirm that they've done so. That way you've discharged some of your responsibility and you can rely on some of these steps as a reasonable steps defence if you needed to do so. Examples from case law in Central and Eastern Europe.
Thank you, Roxane. So examples from case law in CEE. If we have a look at Austria, it has to be noted that already the instruction to sexually harass is discriminatory and may be sanctioned. So not only the conduct itself, but also an instruction. Furthermore, it has been ruled by the highest court in Austria in one case that if an affected person returns similar jokes with sexual content and allusions, this means that no intimidating or humiliating environment has been created, so that no sexual harassment occurred, even if the conduct of the harassing person might have been unwanted. Consequently, all circumstances of each individual case will have to be taken into consideration. Lastly, it has to be mentioned that sexual harassment is not only unlawful during an employment relationship, but also during its initiation, namely during the job interview and within the whole application process. As regards the measurements, investigations, and so on, I only can support the opinion of Roxane to implement measures to prevent sexual harassment also in Austria and CEE.
It's also worth noting that the same applies in the UK in relation to applicants.
Mm-hmm.
Turning to the next slide, There's also an offence for treating someone less favourably for rejecting or submitting to harassment. Now, that offence occurs when A or another person engages in either unwanted conduct of a sexual nature or unwanted conduct that's related to gender reassignment or sex. Now, again, the conduct has to have the purpose or effect of violating B's dignity, and because of B's rejection or submission to the conduct, A needs to then treat B less favourably than they would if they hadn't submitted to the conduct. Now, another example given by the Equality and Human Rights Commission Code is a fairly obvious one, but in any event, they detail the example of when a shopkeeper propositions one of his shop assistants, who rejects his advances and then is turned down for a promotion which she thinks she would have got if she'd accepted her boss's advances. So in those circumstances, the shop assistant will clearly have a claim for less favourable treatment for rejecting or submitting to harassment. We've then got a separate offence of victimisation, and this is often referred to as retaliation in the US. And victimisation can occur when A subjects B to a detriment because B has done, intends to do, or is suspected of doing any of the following protected acts. The first is bringing proceedings under the Equality Act. Second is giving evidence or information in connection with proceedings under the Equality Act. Doing anything for the purpose of or in connection with the Equality Act, or alleging that the discriminator or any other person has contravened the Equality Act. And what we often see here is circumstances when an employee might have raised a grievance or something like that, alleging that they have suffered sexual harassment in the workplace, and then they later allege that because they raised that grievance, they were subjected to detrimental treatment as a result. Likewise, it's also important to note here that employees who give evidence or information in connection with proceedings are also protected. So if you carry out an investigation and speak to witnesses and they give evidence in relation to someone claiming that they were sexually harassed, they should also bear in mind their ongoing treatment and ensure that no one that's involved suffers any detriment as a result. Now, there's no protection if a person makes allegations or gives evidence that they know to be false, but a person who complains mistakenly in good faith is protected. So moving on and passing over to Joe, who's going to talk about how you should carry out the investigation.
Yes, thanks, Roxane. So we know what the law says. Moving on now to dealing with situations in the workplace where someone has alleged or perhaps you are concerned that sexual harassment has taken place. And I think that's an important distinction to make because obviously the easiest way in which a sexual harassment issue can be brought up is by the complainant bringing it up with their manager or with HR. But of course, due to the very sensitive nature of these kind of allegations, it may not be the case that they're willing to bring these allegations forward themselves. So it's also obviously very important for managers and HR people and everyone across the business to be very live to these kind of issues, and just because the person who suffered or potentially suffered the harassment hasn't come forward, that doesn't mean that it's not appropriate to investigate, and you have to be very careful where there may be a suggestion that this has taken place to make sure you're doing the right thing. First thing to bear in mind is obviously don't delay in investigating. The longer it's left without being sorted out, the longer it can potentially go on. And obviously important to bear in mind that this is a very sensitive area. There are a number of people involved and they have conflicting rights and expectations, and whilst you do have obviously a very important obligation to protect people who are being potentially harassed, equally there are issues of confidentiality and anonymity, so that you don't necessarily, it's not necessarily appropriate to be spreading information around the business, for example, that someone has been accused of this kind of conduct before a full investigation has taken place and actually the truth has been discovered. Of course, in these situations, it's very often one person's word against another, so that's why in investigation is particularly important. The starting place with any kind of investigation process will always be your policy documentation. So very important have a policy in place that may be found within your disciplinary policy or your equal opportunity policy, or there may be a separate sexual harassment policy. And we particularly see that with US firms, that they tend to separate it out as having a separate specific policy dealing with that. So that's always the first port of call. The second question to be asked, I guess, is who should carry out the investigation. Important for it to be someone who is sufficiently senior so that they are able to properly look into the allegations. They should also be independent of the people who are involved, ideally outside of the department, so that they don't have any sort of vested interest, and obviously unconnected with the conduct in question. It's also worth considering, if there's no one who is deemed appropriate within the business, or particularly where it's a particularly serious allegation that's being made, is it appropriate to have an appropriate independent third party carry out the investigation?
And that's something that we at Taylor Wessing will do for clients who investigations carried out on that.
Yeah, and we do see that sort of more and more, especially as these kind of issues are getting more to the forefront of people's thinking, and particularly with the more serious and entrenched issues around perhaps more senior employees. In terms of what needs to happen in the process of the investigation, it's obviously important to speak to the people involved, so the accused and the accuser, and also any other witnesses who you sort of reasonably believe may have relevant information. Coming back to the point about confidentiality, what's almost certainly not appropriate is a kind of blanket interview process where you speak to a large number of employees in the department and ask whether they have experienced any similar conduct from this individual, because obviously that's likely to be going too far to investigate the specific issues and potentially calling into question the confidentiality of the individual. It is obviously possible, once an investigation has taken place and a number of people have been made aware of the allegations, if they, for example, turn out not to be true, and actually the individual no action is taken against the individual, if a large number of people in the department have been made aware of the allegations, that could make for a very negative working environment for the individual, and it is possible for them to resign and potentially claim constructive dismissal on the basis that the obligation of mutual trust and confidence has been breached by the employer spreading too widely the details of the allegations. So you do have to be very careful about those kind of things. Just touch briefly on suspension. Quite a lot of clients who I speak to, or certain clients that I speak to, tend to be very keen on suspension, and you do sometimes see people who suspend individuals as a matter of course because an allegation has been made. The important thing here is that you need to look at the circumstances of the situation as to whether suspension is genuinely necessary, for example, to protect other individuals in the workplace, or whether actually the nature of the allegations is not sufficient for suspension to be appropriate. The alternative, of course, will always be, can you instead move the individual to a different part of the business, or somehow separate out the accuser from the accused in order to protect them. That's obviously going to be a less extreme measure than suspending in the first instance. So that's sort of dealing with the first stage, which is the investigation process, which is in some ways the most important part, because it's the information gathering part of the process. Once that investigation has taken place, what is the next step? So the investigating officer will need to determine, following their investigation, whether or not they consider the situation to be such that a disciplinary process is appropriate. Now, they are not taking any decision at this stage on what kind of action is to be taken. They may have suggestions of what the range of potential sanctions might be, but they are not the decision maker. What would then need to happen is a separate stage, which is the disciplinary process. A separate individual will need to be appointed to deal with the disciplinary, who should generally be on at least the same level or more senior than the investigator. And the investigating officer may well attend the disciplinary meeting to present the findings to the disciplining officer, but again will not sort of take any further part in that process. As soon as you have any meeting where disciplinary action may be taken, the provisions of the ACAS Code of Practice will apply. So it's important that you are clear in the UK, at least, on what the ACAS Code says in terms of the disciplinary process. So an individual will be entitled to bring a work colleague or a trade union rep to that meeting, and they should be given sufficient time to prepare for the meeting, as well as copies of relevant documents that will be referred to. It may be appropriate, or it may be something which has happened during the investigation process, that witness statements are drawn up for witnesses who have been spoken to separately. Equally, the individual who is accused may wish to bring with them witness statements, or indeed bring witnesses to the disciplinary meeting to give evidence on their behalf. The disciplining officer will need to assess all of the evidence that is put to them and determine what they believe to be the correct outcome. The level of sanction will obviously be dependent on what the investigation results in, and that can be anything. If it is decided that the accused has been guilty of this conduct, could range from anything from a verbal warning all the way up to a written warning, final written warning, or potentially dismissal on gross misconduct grounds. Roxane's spoken about the concept of victimisation or retaliation, as it tends to be called in the US. Bear in mind that if the outcome of the investigation is that actually the person making the complaint has done that untruthfully and in bad faith, it may be appropriate to actually bring disciplinary action against the accuser. Obviously, it's very important that you're very clear that accusation has been brought in bad faith and untruthfully, but that's another consideration to make. It may not be the end of matters, and disciplinary action may be appropriate against the accusing party. Whilst you're not able to treat anyone less favourably because they brought a complaint, that doesn't apply if they brought it in bad faith. So that's something which is appropriate. And then I'll touch briefly on harassment by third parties. So as a general rule, harassment in the workplace will tend to be from a fellow employee, and I'll touch on that a bit more in the next slide as well. But it's obviously also still an issue potentially in environments where third parties are in the workplace, such as in sort of retail, where there may be customers who come into the shop. Query to what extent harassment by a third party could be held to be the liability of the employer. There used to be specific law on this which said that unless reasonable steps have been taken to avoid this kind of action, that will be the employer's responsibility. That law has actually been repealed now, so there is no specific law on the matter. However, an employer's reaction to third-party harassment or lack of reaction, so a failure to investigate, for example, could well be deemed to be itself harassment or amount to discrimination itself. So very important where there's an accusation, even if it's by a third party, to fully investigate and deal with things appropriately. So just touching briefly on the process, if we get to the unfortunate stage where an employee wishes to complain formally as to the conduct they've received in the course of their employment, by way of sexual harassment. Again, Roxane's briefly touched on the fact that employers will be held vicariously liable for the actions of its employees, but there is a defence where an employer can say that if they have taken all reasonable steps to prevent this kind of action or behaviour, then it may be a defence to the concept of vicarious liability. And this all comes back to the importance of having training in place, having your policies in place, and investigating and dealing with harassment really seriously and appropriately in the workplace, because if you've done all of those things, you may then have a strong argument that actually you as the employer should not be held responsible for an employee's actions in the workplace, although that is quite a high bar to get over. As a result of the concept of vicarious liability, an employee will almost invariably bring a claim for harassment against both the individual and the employing company. So you will normally get a sort of at least two respondents or defendants to that claim. Very briefly touching on the process in the UK, there would be a period of mandatory early conciliation by ACAS, which is the conciliation body in the UK. So before they can bring their claim, they must contact ACAS and at least provide the employer with an opportunity to try and resolve matters before going to tribunal. If that can't happen and a resolution can't be found, whether that's a financial resolution, apology, or anything else which makes the employee comfortable and not wanting to bring a claim, they will then bring a claim. Of course, since the recent ruling that tribunal fees are unlawful, that claim the employee will not need to pay a fee for that claim. As a result of that, the feeling is that claims are likely, the number of claims are likely to increase as there is less of a bar in the way of people bringing claims. So that's something to be aware of. The company will obviously have to prepare a defence for the claim which has been brought against them, and then the process follows the procedure of disclosure, which requires the employer to disclose any document which is relevant to the facts of the matter. And obviously this is the kind of thing which can be potentially quite damaging to an employer, where they have to disclose everything in terms of email and other documents which are relevant, because there can potentially be damaging things in that kind of correspondence. There'll be a requirement to produce witness evidence as to what's happened to date. And they'll, if the matter isn't resolved prior to it, there will be a hearing. And the important point to note on the hearing is that will almost certainly be a public hearing, which means that it will be open to the public. Any members of the public can attend. Members of the press can potentially attend. And obviously, sexual harassment claims are something which the press are very interested in, particularly if it's a high-profile employing company. So it's something certainly to bear in mind, that you are unlikely to want to go all the way to a tribunal, particularly from a reputation management point of view. So that's something to bear in mind. That's just a quick whiz through the tribunal process, and I'll turn over to Brigitte now, who's going to talk a bit about investigation in CEE.
Thank you, Joe. If we have a look at investigation proceedings in CEE, I can actually stress that all what Joe just said about what has to be considered when carrying out an investigation, this also applies to Austria and the other CEE countries. If we have again a closer look at CEE, and here especially at Austria, it has to be noted that the employer is liable to provide for adequate protection against sexual harassment, not only from superiors, but also from other employees or even from customers or third parties. This obligation exists if the employer knows or should know of an harassment. In this case, the employer has then to initiate an investigation, and in general, the same principles as already described by Joe have to be observed in Austria and CEE when carrying out an investigation. However, one has to be aware that sanctions to be imposed must be appropriate in order to prevent future sexual harassment on the one hand, but it must also not be excessive with regard to the conduct of the harassing party. The firing of the harasser may be challenged in case it was excessive, especially if, for example, a relocation to another working place would have been sufficient. However, even a relocation would be unlawful if a warning notice would have helped in the specific case. So this has to be borne in mind. In general, the burden of proof in court proceedings rests with the person affected, who is the claimant. However, this burden is clearly restricted in such cases, namely to the obligation only to show probable a cause for the actual existence of sexual harassment. The harasser then has to prove that the opposite claimed by him or her is true. So that it's not a full burden of proof with the claimant, so with the affected person. Several institutions in Central and Eastern Europe have actually been established, such as ombudsman, that can be contacted in case of harassment. However, their power is often restricted so that no binding decisions, but only recommendations may be made. In Austria, we remark an increase of complaints filed with such institutions, and courts may possibly follow such recommendations. Although actually, proceedings before courts are often closed before any recommendation is published due to the work overload of the institutions. So we see that there is really an increase of complaints. So, nevertheless, such institutions may publish any offences on a homepage, for example, so that actually a cooperation with such institution might be advisable in case of real existence of sexual harassment. The consequences for the harasser may range from a warning to relocation and firing, but it must, as already said, be adequate with regard to the conduct. The payment of compensation of a minimum of €1,000 may also be imposed, even if there's no actual damage provable. However, higher damage may also be claimed if this can then be proved. The employer may in this respect also be held liable for such damages if no adequate protection was provided against sexual harassment beforehand. So this was a short overview on investigation proceedings in CE.
Okay, Joe, although we're focusing on sexual harassment here, in fact, there are other protected characteristics which have harassment laws attached to them as well, aren't there?
Yeah, it's important to remember that harassment can take place against a number of different protected characteristics. Obviously, sexual harassment is very much newsworthy at the moment, and it has a certain sort of specific set of circumstances around it which make it particularly important in the workforce, but the concept of harassment does extend to a number of the other protected characteristics under the Equality Act that are listed on that slide. So age, disability, gender reassignment, race, religion or belief, and sexual orientation. Point to note on disability is that as with sort of direct discrimination, the individual must first show that they are disabled in order to claim that they have been harassed on the basis of their disability. So it can't just be that someone harassed someone because they think they might be disabled, for example. Whilst marriage and civil partnership status and pregnancy and maternity are not specific protected characteristics for the purposes of harassment law, if someone is treated less favourably on any of those grounds, this could give rise to sex or sexual orientation harassment claims, or indeed be examples of direct discrimination where these protected characteristics are protected, direct discrimination.
Right, and so just in conclusion, some very key points if you don't already have a policy in place. It's absolutely vital that you have one. Although if you're an international company, the law might be broadly similar across your network. It's not exactly the same, so do make sure it gets tailored for wherever you're working. Consider training for managers and all other employees. If you do have training, that is potentially going to be a defence if you ever get into litigation, even if it's not legally compulsory. And bear in mind that employees appearing to consent to behaviour that would otherwise be sexual harassment in the workplace often is not a great argument to be running in litigation. It's going to be fairly unusual that a court in Europe is going to think that somebody has consented once they do make an allegation of sexual harassment. Bear in mind that the duties of care are owed to both the complainer and those who are complained about. Nobody is guilty until the investigation has been carried out and everyone's been given and the rules of natural justice have been complied with. If you do have any questions, do send them through to us and we will reply to them. Needless to say, if we can help you with policies, training, or with any investigations or any other disputes in this area that you may experience across our European or Asian network countries, do let us know. We'd be very happy to help. So thank you very much for joining us. I hope you found this useful, and I look forward to you joining us in our next EMEA General Counsel webinar.